Good morning, ma'am. Are you Ashley Broussard?
Yes, ma'am.
And Ms. Broussard, in cause number 25 DCCR 0175, you're charged with the third-degree felony offense of injury to a child from October 28th of 2024. And what that means is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand? And I have here on the computer a plea bargain rejection that you've signed with Mr. Kimler that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 5-year deferred probation, a $500 fine, and you would be required to follow all of the rules and conditions of probation. Also, I'm sure Mr. Kimler went over with you that that type of probation, if you're successful, means you don't have a felony conviction on your record. Do you understand?
Yes, ma'am.
You have every right to reject that offer and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that? And do you want to reject that offer and have your case set for trial? All right, we'll get that done. I also want to make sure, Ms. Broussard, that you understand that after today, I will not accept this plea agreement. If you change your mind to want to plead guilty, you can plead open to the court. It could be to some different agreement, but it won't be this one unless there's some new information that your attorney or Mr. Smith gets between now and trial. Do you understand?
Yes, ma'am.
All right, then I'll get it set on the trial docket, and Mr. Kimler will begin preparation for trial. You're free to go.
This case and the arrest, I think 3 or 4 months, right along, when CPS was investigating the case where she had custody of the child, or at least was visiting the child. But
They
with
were with me up until the arrest.
What?
With CPS.
Y'all can't both talk at the same
With
time.
CPS supervision without any problems. Then when she was arrested, there was a condition of bond that she not have any contact with the child. CPS doesn't have any issues with her having visitation or contact with the child. We were just asking the court remove that bond condition because it's impacting her relationship with the child. And I think the child's development. How old's the child? 3 years old.
Give me just a second. Can you hand me that when I'm printing, please?
Who was the CPS investigator?
Sydney Kirk.
If you have any questions of her, we can run it over.
Mr. Smith?
If Mr. Smith has any questions, run it over.
Now I'm asking what your position is.
It's opposed, Judge. And again, I would just observe that there was about approximately 4-month period prior to her arrest. There were no incidents.
But that was,
There's a co-defendant in this case, Dallius Williams. We had a hearing on this. I believe it was an MTRP on Mr. Williams. So you've seen the evidence in this case. I don't know if you recall it, but the child was 2 years old and nonverbal. And showed up at school Friday, everything was fine. Shows back up, misses Monday, shows back up Tuesday. The marks are there, and allegations are that those were the only people around her at the time.
And I would just observe that there was a CPS investigation subsequent to that where the child remained in contact with the defendant with no deleterious consequences reported.
no, what consequences?
Bad consequences.
No,
Harmful.
what's your word?
Deleterious.
It's not gonna be my word of the day to learn.
One of those SAT vocabulary.
Mm-hmm. It's been a long time since I took that. I'm trying to recall that hearing. I feel like that Mr. Williams was maybe more culpable with regard to the specific allegations, not necessarily not turn them in and things like that, but the actual physical.
And then when the police started the investigation on this, she lied to the police.
Allegedly. She didn't cooperate. We can agree on that. It was non-cooperative.
The only thing I will do, I will modify the bond condition that you can have contact with the child, but it is only to be supervised. So you are never to be alone with the child, period.
Is that through CPS supervision or who's the supervision?
I don't, if CPS isn't involved, I can't order them to supervise. So y'all work on figuring that out, but there has to be another adult, some adult at all times, not a 16-year-old, an 18-year-old, someone.
Grandma didn't live with grandmother, so I'm sure she.
Okay, perfect. Then I'll let you have visitation so that you can, obviously, I think this is something you will be able to get past. You'll be able to hopefully work towards more than just this, but I want to start off with me feeling comfortable with that until we figure out what's going on in your case.
Just
Okay.
in the interest of specificity, she's only to have contact with the child in presence of the grandmother. What's the grandmother's name?
Dana Williams.
Dana Williams.
She's
Okay.
only to have contact with the child in the presence of Dana.
Mr. Stewart, you tested positive for THC, methamphetamines, and amphetamines, which is obviously a violation of the condition of your bond. When was the last time you smoked marijuana?
Maybe like a week ago with somebody.
When's the last time you used methamphetamine?
Shit, about a week ago.
All right, so Mr. Stewart, obviously, as those are violations of your bond, what is his bond set at right now? Let me see if I can find it too. Give me a second. Five. So, Mr. Stewart, I'm going to raise your bond because you violated, obviously, the conditions of it by using illegal substances. I'm going to raise your bond to $20,000. A condition of that bond, if you make it, is that you will be required to have a drug patch on at all times. You will have 24 hours from the time you're released from custody if you make that bond to get the drug patch on. You will have to go get that changed every 2 weeks. If it tests positive and you make that bond, the bond's going to go up and you're going to be back in jail. You're using drugs 1 week before you come to felony court while you have go back with the bailiff. Good morning, sir. Are you Michael Anthony Thomas?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He does, Judge.
Mr. Thomas, in cause number 23, DCCR 0530, you're charged with the second-degree felony offense of indecency with a child by sexual contact from October 1st of 2019. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes,
And it looks like the agreement that you've reached is for a cap of 4 years in prison, which means you'll be leaving your punishment up to me. As long as I don't give you more than 4 years in prison, then you can't appeal. If I can give you 4, 3, 2, I can consider probation. It'll depend on all the information that I receive at a sentencing hearing. You have an absolute right to have a jury come in and determine 2 things, if you're guilty or not, and then if they find you guilty, what your punishment is. Your case is actually set for trial to begin next Monday. So if we go forward this way, you're waiving the right to the jury, and you're going to want me to go forward this way. And is that what you want to do?
yes, ma'am.
Do you also understand that a plea of guilty or no contest, if you're not a U.S. citizen, may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? In addition, did you do the sex offender registration paperwork?
No, we did not.
So I'll go through it, and then before you leave today, make sure and get that done. And so also, do you understand that as a result of this plea, you will be required to register as a sex offender? All right. State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Thomas is not competent?
No, Judge.
Bernica Conning? And Ms. Conning, you were previously in court and entered a plea of guilty to aggravated assault with a deadly weapon, second-degree felony, I've received the copy of the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Your Honor, we have.
Are there any additions or corrections?
Not from the defense, Your Honor.
No, Your Honor.
All right, Ms. Conning, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings for a period of 10 years. You are ordered to pay a $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And at the end of the probation period, the case will actually be dismissed if you successfully complete it. The other side to that, however, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sentenced to prison for anywhere in that range of punishment, which is between 2 years and up to 20 years in prison. Do you understand? Part of your probation, the conditions, is that you have absolutely no contact, obviously, with Anaya Johnson, Nikki Lawrence, Lyric Lawrence, and Deanna Darjean. Do you understand? That doesn't mean just in person. That means any contact or communication. No sending messages through DMs or any social media, emails. No telling other people to tell them things. Stay away from them, steer clear so that you don't end up back here in trouble and going to prison over anything like this. Do you understand? Also, you are not to be anywhere near the Regent Street apartment complex in Beaumont. You understand that as well, right? Okay. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I will be signing dismissals in cause numbers 24 DCCR 1574, 1576, and 1577 as part of this agreement. If you just need to have a seat here in the courtroom, and then probation's going to call you up to her desk when she's ready to go over your.
Thank you, Your Honor.
Thank you. What's his name in the back? It's about to go.
Is that an initial document?
Mm-hmm. No, I'm just going to revoke this. That, it doesn't show a state's attorney on that one.
Wait, hold on, I just got it. I just put it in.
The PC on that one,
Hold on.
the high-speed chase was crazy. I wonder whose it is. I mean, like 100 miles an hour down 105. They went from here to Hardin County and back and jumped out and ran in the woods and threw out drugs. So, all right, Mr. Johnson, come on up. Mr. Johnson, in cause number 24, DCCR 2265, we've already gone through this, but you're charged with evading arrest or detention with the use of a vehicle. I have reviewed the pre-sentence report in your case. Based on that report and the fact that there is an allegation, obviously an allegation of a high-speed, very dangerous chase, but in addition to that, there's an allegation that drugs were thrown out of the vehicle during that chase, and that's why I ordered the drug test this morning. It's now 11 o'clock. I ordered this drug test prior to 9 o'clock. You have not been able to go or refusing to go to the restroom. Based on that, I am going to find that I'm going to assume that you are positive and that it is in the best interest of our community that I raise your bond, which is currently set at... Give me just a second to figure that out.
It was at 10,000.
10,000?
Yes, ma'am.
I'm going to raise your bond in your case to $30,000. A condition of that bond, if you make it, is that you wear a drug patch at all times. You will have 24 hours from the time you are released, if you make that bond, to have a drug patch put on. Your bondsman can let you know where to do that. You have to change it every 2 weeks. If it tests positive, you would be right back in custody, obviously. If it's not testable, then it's also going to be considered a positive drug screen. You can go back with the bailiff.
Can I say anything right now?
Not today, not now.